on behalf of the contemners, Mr. Bandyopadhyay had concluded his submission.
Yes.
And supporting state or the others, they have adopted the submission of Mr. Bandyopadhyay. Now, what I submit at the outset is, once the rule is issued, I am the informer. I am neither the petitioner nor a party otherwise. I have informed the court that this has happened. Therefore, matter is now between the contemner and the court. And I can make submissions only if the court requires any assistance from my end. Otherwise, not. So that is the position of law according to me. Now, if your lordships feel that my submission will be of any assistance to your lordships, then I can try to assist your lordships.
Mr. Sengupta, we would like to require your take on this, on the technical maintainability point taken by Mr. Bandyopadhyay.
Yes.
And also on the involvement of respondent number 8, because the other respondents virtually they have apologized and said the context. Maintainability and involvement, if you can throw some light on that.
Grateful to your lordship, grateful to your lordship. Lordships are dealing with this case. It's of great moment because some people are trying to undermine the dignity and majesty of the court. One, by humiliating one sitting judge of this court in respect of a matter where these persons were parties. And what we have done is simply we have brought it to the notice of the court. My lord, we can say this is the situation. Go to
Section 15 even assuming there is jurisdiction, suo motu cognizance would not have been taken under Section 15 in the manner it has been taken.
Yes. But answer is very simple.
Yes,
Now,
Section 15.
in the case of a criminal contempt, other than a contempt referred to in Section 14, the Supreme Court or the High Court may take action on its own motion or on a motion made by the Advocate General, any other person, the consent of the Advocate General, or in relation to the High Court or Union Territory. Such law officers of central government may by notification the official get to specify in this behalf, or any other person with the consent in writing of such law officer. Now, my first submission of this is it the enabling power giving High Court the jurisdiction? My respectful submission is no, because the power comes from the Constitution itself. Constitution has clothed the Supreme Court and High Court. In my respectful submission, if not dealt with stern, it will only encourage persons not only to disrespect the honorable judges, but also.
Sorry, please proceed.
We also see the definition of criminal contempt. Criminal contempt means the publication, whether by words, spoken or written, or by signs, or by visible representations or otherwise, of any matter or the doing of any other act whatsoever which scandalizes, here it does not end, or tends to scandalize, or lowers, or tends to lower the authority of any court. So what this is broad enough to take within its ambit, or prejudices or interferes, or tends to interfere with the due course of any judicial proceeding. So, staging a garrow before, in front of the chambers of the learned advocates who are appearing and shouting slogans. Your lordships did not issue a rule on the first day. We had a conference of 2 hours.
He refuses to stand up. Just now he has stood up.
Possibly he has not heard what I say.
2010 HSSC 673.
But we have a copy already, don't we?
Please repeat the citation once.
This is 2010 HSSC 673.
2010 8 SEC.
We are also relying on this.
Correct.
So, Mr. Shengupto,
Yes, sir.
the way you are putting it, can you say this? That the Honorable Chief Justice, the affidavits were filed, those were captioned also as complaints. And there,
Yes.
Suomotu rule was prayed for before the court's jurisdiction was sought to be invoked, that you issue a Suomotu rule. We are not the petitioners.
Yes.
Those materials were before the court, and as is apparent from the Chief Justice's initial order assigning before us, that video clippings were produced, those affidavits were there. On these materials, Chief was of the opinion, Honorable Chief was of the opinion that this matter is serious, a bench should be constituted and place the materials before us. And then we also gathered further materials by seeking affidavits from the alleged containers. And after getting those materials, on the first day we did not issue a rule, as you said. And then it is this court which issued the rule for the first time after getting those materials, including the video clippings.
Yes, sir.
This can be governed by, arguably, by Rule 17, which does not confine it to the Chief Justice. It says rules issued by any court on its own motion shall be dealt with by that particular court. So the Chief, what the Chief Judge does is only constitutes our bench, assigns these materials to us, and leaves it on us to take a call as to whether we shall issue a rule of contempt. This is
Your Lordship, yes, Your Lordship has put it more precisely than I could. I was just drawing Your Lordship's attention to the expression, notwithstanding anything. It does not mean
it's over and above. It's super additional. In addition.
That's right.
That's very.
Therefore,
And
yes.
particularly since this is criminal contempt. So
yes.
now under the new provisions it has changed. So
It
it's
is
no
changed,
difficulty.
yes, but not
Exclusively on the affidavit. If it's exclusively on the affidavit, then no. That is the distinction. No, he has not marked anything else. This is sufficient.
More
We
judge.
are not citing any other judgment, Mr. Shengupta. Now on respondent number 8, you can just.
I just point out there are judgments cited by Mr. Bandyopadhyay, whether that should be distinguished or not. If Your Lordship, these are all judgments, Your Lordships will read it for advancing the.
Mr. Shengupta, I don't think those judgments need to be dealt with.
I'm grateful to Your Lordship.
Principles of law are fairly well settled.
Yes, so far as respondent number 8 is concerned. But what was the basic stand? My lord, I was not present there. I was holding a press conference before in Newtown. But it's not an essential ingredient of criminal contempt to be present in the place of contempt. I can commit criminal contempt sitting here while submitting before a court. So I was addressing a press conference. There is no ground to say that criminal contempt has not been committed. And I do Your Lordship's kind attention, Section 2, subsection C of the Contempt of Courts Act, to say, which tends to lure, tends to scandalize. This tends to is making it very wide. That is being staged, and clippings of press conference were translated for the court. Not only one judge, a number of judges, aspersions were made.
Mr. Shengupta, shall we reassemble next week?
Yes, Lord.
Mr. Parthu Sharathi Shengupta, Commander Senior Counsel, makes his submission
Okay.
on behalf of one of the informers. He does not conclude. Paragraph lists this matter once again on OE, marked 3:30 p.m.